Good afternoon. This is Peter Thomas from Washington, D.C., National Association for the Advancement of Orthotics and Prosthetics General Counsel, to update you on RAC audits and appeals of orthotic and prosthetic claims. This past week, we learned of a report published by the Centers for Medicare and Medicaid Services that was required under federal law, an annual report that relates the progress of the recovery audit contractors. This report covered the span of fiscal year 2013. The report is interesting in the sense that it uncovered about $3.75 billion in recoveries that the RACs were ultimately responsible for. That differs from the previous fiscal year 2012 of $2.4 billion in recoveries to the federal government as a result of recoveries from providers. Now, the interesting thing is that 98% of those recoveries came from acute care hospitals, and so only 2% are coming from durable medical equipment, prosthetics, orthotics, and supplies. Interestingly as well, only about $102 million were provided in the form of overpayments. In the form of underpayments. In other words, payments that needed to be made back to providers who underbilled the program. So compare that, $3.75 billion in recoveries for overpayments and only $102 million paid out in the form of underpayments to providers. Ultimately, RACs recovered about $301 million in contingency fees over that fiscal year, which suggests that these contingency fee payments are a major incentive for these Medicare contractors to do the kind of work that they're doing. Now, NAAOP continues to be concerned with the way that these data are collected and the fact that there is very little in the form of specific data related to orthotic and prosthetic claims. The tail is kind of wagging the dog on this. The agency is reviewing data that primarily relates to hospitals and Part A providers and is, in a sense, applying that to orthotics and prosthetics with very little breakout of the data available. That's one of the reasons we support some of the very key provisions of a bill called ultimately the H.R. 5083 introduced by Congresswoman Renee Elmers. Three provisions in that bill are critical for the orthotic and prosthetic field. The first is that it would clarify that prosthetist and orthotist records, clinical records, are part of the medical record for determining medical necessity. The second thing it would do, and this relates to the collection of data, it would separate out orthotic and prosthetic claims from durable medical equipment claims and Part A claims as well, to make sure that there was a much more accurate accounting of what's taking place with respect to audits and appeals in the orthotic and prosthetic field. And third, it would recalculate error rates of O&P claims, considering what happens to those claims through the appeals process. So those are really important provisions that we're working to try to maintain and to get ultimately included in any kind of a bill that moves forward. We do not expect the Elmers legislation will move forward as a block, as an entire piece of legislation. But we are hoping to kind of build support for the three provisions I just mentioned and to have that included in a broader legislative vehicle that might be moving later this year or perhaps next year if Congress does not reconvene in a significant lame duck session of Congress after the election. Finally, let me just inform you that there is a lawsuit that's pending that the American Hospital Association filed against the Department of Health and Human Services relating to the 2-year delay in referrals of ALJ requests to ALJ judges. That delay is having a very serious impact on the ability to get cases heard before administrative law judges. And so a lot of these cases in the backlog are being, ultimately the federal government is holding providers dollars and seriously restricting cash flow while these hearings are being held at quite a slow pace. The problem is getting worse, not better, and that's one of the reasons the American Hospital Association filed suit. The NAAOP is monitoring this closely. We're actually working with a coalition of other groups in monitoring what's occurring with that litigation. There will be a friend of the court brief submitted by a group called the Fair Fund, which is primarily related to inpatient rehabilitation, but they are detailing a lot of the impact that this 2-year delay, and we all know it's much more than 2 years, is having on providers generally. And so that litigation will proceed. We're expecting some kind of decision in the next several months, and we'll keep you informed as developments occur. Thank you very much.